Good morning. My name is Don Vivrette. This is It's Your Estate, week 4. We're going to discuss living trusts. I welcome you very much. If you look at your screen, if you move your mouse around a little bit, you'll get a box across the bottom that one of them is Q&A, question and answer. And what I would ask that you do is if you have questions, type them in there. I'm going to monitor those as we go throughout the session. And if I can answer them, I'll answer them, or I will ask Pete and Jim, who's presenting today, any questions he has. If you use chat, which some people like to do, it is harder for me to respond to you. So I will just tell you that's an upfront Pete. So I am going to say, welcome, Pete. And do you want the website up?
Yeah, let's
instead of looking at us.
Yeah, let's just briefly go through it because people still, it's not as intuitive probably as it should be. So the first thing you do when you go to our website, and by the way, our website address is iyme.org, and or you can type in itsyourmoneyandestate.org, but IYME, a little shorter, a little quicker. So when you get to our website, click on workshops, then go to the materials page, not to the It's Your Estate page yet, the materials page, and then go to the It's Your Estate button. And then as you can see, it says week 1, scroll down to week 4. And week 4, there's our presentation handout, the bio for our speaker, his Ask First form. And if you scroll down further, you'll see articles related to what we're going to be discussing today, and that is living trust. If you like other articles, there's other articles on our website, and there's also an entire Zoom series from our spring session. And that just means you go to workshops and you immediately go to the It's Your Estate section. So let's get out of this.
Well, just for one thing, incidentally, if you thought this was interesting after you've watched it, for instance, I just scrolled us back up to week 3. The first thing it says is watch the webinar replay. So normally, unless I mess up or something else happens, within a week, the webinar will be up for you to watch it from a video standpoint. So you can rewatch this in about a week. It's up there. And as you can see, watch whatever we did last week, incapacitation, it would be there and you could watch what they had gone through. So I'm going to stop share. And we're back here.
Okay. Before we get into our presentation today, Lynn, why don't you come online? Lynn Marie, I love that name, by the way.
Thank you, Pete.
Lynn Marie, what do you do?
I am the executive director for the City of Orange Public Library Foundation. And what the Library Foundation does is our mission is to raise funds to fill in where tax dollars do not meet the needs of our public library. The goal is to make sure that we always keep public libraries free and available to all people to continue their educations in any way possible. At the foundation, we provide critical funding to the library for technology, local history, and new books. We support the needs of the disabled, the elderly, the homeless, families, children, teens, at-risk youth, and all community members looking to expand their knowledge and abilities. The OPLF Foundation, we provide annual programs like our STEAM for Teens and Tweens. We work with Southern California Edison and Chapman University with that program in grants and offer STEAM opportunities to kids. At the end of each program, we've been able to raffle off actually a laptop, a printer, and software. This past year, we were actually able to do 4. We were able to do it through COVID via Zoom, and we created kits for the kids to come into the library and pick up, and so that it was actually a hands-on workshop that they could do. So that is one program that we're extremely proud of. We've had most of the kids this past time, 2 of the kids that won the computers didn't have computers in their home. and which is extremely difficult with, obviously the kids did a lot of their classes online. The Orange Unified School District made sure that computers were available to all kids in the district. So they also, anybody that was interested in our program, even if they weren't in this Orange Unified School District, we worked out that they would make sure that they could get a computer. So that's a huge success story. And on top of that, we had another gentleman who is now going into his sophomore year of college. His first year was during COVID, and he participated in our early STEAM programs, became interested in STEAM. We sponsor a robotics team. He became part of that robotics team, and he attributes the Community Foundation for this opportunity, and he actually got a full ride scholarship to MIT. So, which is huge. Yeah, it's really exciting. He also got a full ride. He got offers from many, many schools because of all of the participation in STEAM programs, in the robotics. He taught some of our STEAM classes when he was in high school. He just did phenomenal. So it's really nice, like I said, because he came in and ran up and thanked us, like, thank you so much. I wouldn't have ever known or been able to do this without this help. So that's a huge thing with it.
Marie, when I was growing up, the library was always a great excuse to get out of the house and then do something else. Mom, Dad, I'm going to the library. But
well,
today,
a lot of that's still the case. They do
really
come. Now we have, like I said, with the technology and that the libraries, people think of libraries as just books. We're not just books. As you can see in the picture right there, donations at work, we have all computers for learning, early learning. Some people don't have access to computers. They don't have access to the technology. We've actually just recently gotten a lot of hotspots. We saw a huge digital divide that became even more aware during COVID. We're just now getting back to opening the library. And if you he scrolled up, you saw the homework center. The Library Foundation provides support to help pay for the libraries, for the homework center, that kids can come here after school to get help with their homework. So it's a great excuse to leave, Pete, but kids also get a tremendous amount of help here with it.
But, people don't realize libraries, first of all, from all the other charitable organizations, are one of the most difficult charities to raise money for. And I'm not sure exactly why that is, but it is. People have no clue how difficult it is. But what's amazing to me, how integral you are in the community.
And we have to be. I mean, everything, like I said, our goal is to make sure that the library is able to have enough funds to provide the extras, such as, computers, et cetera. And that's what a library is. A library, as you said, is not just books anymore. There's so much more. And we do have to be out there in the community, be educating people. There's a lot of people that are extremely privileged and don't have any issues. Books are easily accessible. Technology is easily accessible. But there is a large percentage of people that don't have that accessibility to either of them. So we are out in the community and trying to raise funds, create programs, and people realize how worthwhile it is.
Do you ever have a need for volunteers?
We use volunteers excessively. I mean, we when we have our gala, which is one of our big fundraisers for the year, our volunteers help us run the program, because realistically, the foundation, we do have a board, but as far as employees, I am their only employee. I do have an assistant who used to have my job, and she works approximately 10 hours a month. But at certain times of the year, it's more. So we very heavily rely on volunteers to help us with seed sorting. We have a seed lending library. They help us at our different events. The volunteers work at the homework center. So all of that is
speaking of the homework center, one of the things that I went to visit a gentleman, and he just went on and on and on how much he was in his 80s and how much he got out of helping out the kids, and how that, I said, well, that's great that you volunteer. Oh, no, I get so much more out of it. It's all about me. I love it.
Yeah.
So people
It's,
forget that, that this stuff is good for you.
yeah,
And
exactly.
and Lynn, if I recall correctly, pardon me, I become the voice of God at this point, so I just get to speak without a face. You're unique as a library because you're not a part of the county system.
No, we are not part of the county system, so we do not receive money from the county. We are from a city supported by the city. We have 3 different branches. We have our main library, which is in Old Town Orange, and it has a history center. We received a grant 15 years ago to rebuild the library, which was originally built by Carnegie Mellon Grant. And we have a history center, local history center in it, so people can research homes in the area. We have all different types of information on there. And then we have 2 branches. One is in the El Medina area, which is about 6 miles east of the main library. And then we have another one just north of the main library, about 3 miles, and that is the Taft Library. So yeah, so we do all of our own funding with it, but we have a huge outreach. I've talked a lot about kids and the things that we do with them. We also do a tremendous amount for adults. We have a literacy center that we support, that there's a lot of adults that can't read that can come in here and they sign up and they are taught how to read. So that's something else that we do with it. And we have, to raise funds for the library, we have a gala every year that I briefly spoke about. People can purchase, we have a orange giving tree in the library that was started when we rebuilt it. And we can Jim, or we can, are you pulling up the website still, or?
No, it's down.
Okay.
Because we got to get kind of going.
Oh, we've got to get going. That was my cue and I missed it. Anyway, so that is the Orange City of Orange Public Library. We would love to have you come visit us, support us. He put our website up, and we look forward to it. One of the big things that we do is our financial literacy. So, which we've been
doing. The El Medino branch. So
currently at the El Medina branch. In the spring, it will be back at our main branch. So thank you very much for the opportunity. And I hope you guys all have a great day.
Lynn Marie, thank you so much for being a sponsor.
Oh, thank you. Thank you for allowing us to. We enjoy the program.
Thank you.
Thanks, Pete. Okay.
Bye-bye. We'll see you soon. Okay, let's get started on our program. You want to pull up the presentation or the Ask First form for Jim. But before we go ahead and introduce Jim, briefly, we're going to go through a brief review. The first session was a brief tax update and a little introduction on our financial and estate literacy. Financial estate literacy is also a 501c3. We don't allow any for-profit sponsors. Our mission is to educate you on money, charitable, and estate planning. That's our mission. So hopefully we're doing that through these workshops. The second session was about basic estate planning. So you need a will, you need a durable power of attorney, you need an advanced healthcare directive, and you need a living trust, which we'll talk about today. Please remember how important title is to assets. How you hold title determines what document you're going to need when you're going to need help. We talked about planning for incapacity, the advanced healthcare directive, and also the durable power of attorney. Make sure you take your durable power of attorney to your financial institutions to see whether or not they will accept your attorney drafted one, or will they ask you to complete one of theirs. Also, make sure that you understand whether you have an immediate durable power of attorney or a springing. If you're 70 and over, I kind of recommend that you do an immediate, but we can talk a little bit more. I'll ask Jim what he thinks, and we'll go from there. The Advanced Healthcare Directive, I think, is one of the most important documents of the entire 4 documents that we've been talking about. The problem I see is that we don't spend enough time communicating with our agent for our healthcare. And I recommend a booklet Your Way. It's not a legal booklet, but it talks about how you feel, about hospice, about morphine, how whether you want to die at home or in the hospital, or what's important to you as far as values are concerned. It's a wonderful little booklet. It's on our website as to how to get a hold of a copy, and it's free. So Jim, why don't we pull you up, come on board, and we'll quickly go through your Ask First form. Hello, Jim.
Hey, Pete. Good to see you.
Good to see you. Full disclosure, Jim and I have worked together for about 30 years, although he doesn't look like it. I do. And his total practice, what Jim does morning through night, is estate planning. So you've been in your 39th year, 40 years. Jesus, Jim, you've been doing this a while.
You know, Pete, I started at 2 years old, so it was like just part of me.
Okay, your practice is one of the best in the community in the sense that you're not a national firm. You're a local firm. How many attorneys do you have working just in the estate planning area in your office?
You know, Pete, I didn't go to law school for math, so correct me if I just miss it by one or two people, but I think it's around 12 people now in our group. I started out, oh gosh, when I first met you, Pete, with myself and a secretary named Mary, and it's grown significantly since then.
And Mary is still there, right?
Yeah, you know, I tell Mary oftentimes, Mary, when are you going to retire when I turn age 80? Okay, and she doesn't look at me very happily after I say that. Yeah.
So, let's go right to compensation.
Okay.
Because we want to talk a little bit about how does your group charge? Talk a little bit about fees. You handle estates. I've seen as little as 200,000, and I've seen as your estates handling $1 billion plus. Right. So talk a little bit how you charge.
Well, typically it depends on the size of the estate, Pete, because obviously it's just common sense that the smaller estates wouldn't require as much effort or work or analysis. So for the smaller estates, we charge on a flat fee only basis, and we try to make it within a little lower, if not significantly lower than what our competitors are charging. In other words, there's a marketplace for this type of service. It's not the Zoom, not Zoom or, Shapiro's latest invention with regard to creating estate plans. It's not that low, but it's not the upper echelon with regard to the national firms.
If I have $1 million estate, I'm single, 3 major assets, what would you approximately what would you charge? Because whenever I get scared when somebody says I have a simple estate, how much would you charge?
Well, it really, again, there's a range.
Okay, what's the range?
The range for us is around from $2,500 to $3,500, depending on the size of the estate.
Okay,
that's for a single individual.
Single. How about if I was married?
If you're married, it begins at $3,000 and it can go up to $4,500, depending on the assets in the estate.
Okay, and then do you offer during this period of time? Are phone calls, emails, are they included in that flat fee?
Well, yes, absolutely. Here's what we've done just recently, Pete. I don't know if you're aware of this, but we get a lot of calls from people who are just looking. They're looking to find an attorney that they can connect with. I like to think of estate planning is really a relationship, because as we'll learn, when you create an estate plan, you just don't push it in the bottom drawer and never look at it again. You should be periodically reviewing it every 2 to 5 years to see, hey, have things changed? Do I need to make some change in terms of tax law or or with regard to relationships.
Mhm.
In my opinion, estate planning is as much about finances as it is about relationships, maintaining relationships. So there's financial capital and there's human capital. We want to make sure we're very cognizant of relationships because a bad plan can destroy families.
So during the period while you're putting the estate planning together, there are normally normal communications are not an additional charge.
No, no.
Okay. And then-
Remember, we have two types of people in the world, engineers and non-engineers.
Okay, well, engineers, I would charge the hell out of them.
You and me both, brother. And in my early years of practice, I learned that very quickly.
Yeah. When I was at Long Beach State University, I could never carry enough books to the engineering department. Because of the number of questions. We love engineers though.
We do. I find it challenging.
Yeah.
They may not like the fact that I have to build them more, but I find it challenging.
Do you offer any free when say, hey, I need to update my estate plan, but I don't really know what I need to do? Do you offer a free phone consultation or a free in-house consultation? Because they don't know whether or not they like you as a relationship.
Yeah, we've gone to the point of charging for like half my hourly rate for that type of a conference, because we find that a lot of people are just looking to get information and they want it for free. And frankly,
yeah, well, that's why the workshops are. We don't charge, so we're
that's
free.
Exactly right. What you need to do is go to Pete, because Pete doesn't charge you, right?
Okay, so you have 12 different attorneys or staff in your office. Hourly rates. I can't believe all of your hourly rates are the same. So give us the range of your hourly rates.
So let's just understand that for estate planning, which is basically the fundamentals, that's going to be always on a flat fee, no matter what attorney and what hourly rate that attorney's basically billing you. Okay, so it's going to be a flat fee. The only difference is that if it goes beyond 4 hours worth of face time, then we have to start charging on an hourly rate. So the rates differ from $350 to basically almost $600 per hour.
Okay.
And I happen to be at the top of that totem pole, unfortunately.
Yeah,
nobody ever wants to talk to me.
I was talking to Mark Powell from he did our incapacity session, and he works for Knight in Holland. And his rates start at $950 an hour. So at $600 an hour, you're a bargain.
Yeah, you could call me cheap, but that wouldn't be true.
Yeah. Okay. There's many more things to learn about Jim. Just a wonderful, nice person. One of the things I like to bring up, because a lot of times people have special needs kids, and you've been raising a child who has autism, which is an enormous challenge, but also in the estate planning area. So what I'd like for you to do is towards the end of the program, talk a little bit, we'll ask about special needs trust, because I think you can add a lot of your personal stories involved in the technical part as well. So let's go to the outline.
Jim, if you want to go ahead and share that screen we had up. Oh, there you go. Hey, got it. Thank you.
So, I was telling Pete earlier that I can spell IT, but that's about as far as I can go. But so thankfully, we've had the opportunity to speak here with Don and everybody else to get this going. But bottom line here is you can look at my bio. It's online too. Please use it for whatever you need to use it for. This is basically our standard process with regard to estate plan, and we'll go through it. This is me. I'm a senior partner. I'm basically one of the oldest partners in the firm. The good news is that we've got succession. About 15 years ago, we decided on succession, which means that whenever I decide to retire at age 80 or whatever, that there are younger people. I know Pete's worked with some of them already in our firm who are clearly smarter than I am and really good attorneys as well. So that's the good news. I'm a certified specialist. I've been doing this for, again, 42 years, I think it is, last count. And since that is the idea, I graduated and got a master's in tax. You've already learned from Pete and from the prior sessions, if you will, that the big issue here with regard to what I call estate planning and having to do with trusts is to understand how properties transferred, both on incapacity and at death. And you've talked about conservatorships, you've talked about powers of attorney, all of which are still part of the puzzle, the estate plan, even though we're going to talk about trusts. So it's not like you're going to give up those other documents by what we're doing today. It all fits together into a bigger piece of the puzzle, if you will, all of which have their important aspects. I'm not going to go into each one of them because you've done that, but we're going to talk about the trust today at length.
Yeah,
So
Jim, I love the fact that you put incapacity first,
right,
death second, because these documents are about while you're alive, especially the living trust.
Yeah, that's why we call it a living trust, right? Because it's really involved. If I should become incapacitated with these things in my hand, guess what? I can't sign my name. So somebody's going to have to come in, if I haven't planned properly, and transfer my accounts, pay my bills, do all that stuff. And we've already talked about that. That is the durable power of attorney for finances.
Yeah.
But it's greater than that, because what we're going to talk about today is a way to avoid even those by transferring your assets to something called a trust. Here's my trust. See, it says James on it. That's my trust. That's my trust. So, and then obviously then at death, if I die with these assets in my hand, what happens to them, Pete?
You go through probate.
Yeah. So probate is a 5-letter, 4-letter word. You do not want to go through probate in Orange County. The reason for that is it takes years potentially to get it through that process. And the reason for that is this: when I die, guess what? I can't sign my name. Right, Pete?
Well, I don't know. You've been doing some amazing things, Jim.
I don't recommend my clients try it. Okay,
Yeah.
Please don't go home and try this.
Yeah.
But the bottom line is if you haven't transferred it out of your hands prior to your death, somebody has to do it because you can't sign your name.
You got it.
And hence right now, as you were speaking, if you're watching this particular presentation, it's very likely that you can sign your name to be able to transfer these assets into what Jim calls a trust. That's it right there. So essentially, we're talking about if you become incapacitated, a trust takes these assets without a court process called a conservatorship. And if, God forbid, your power of attorney fails for whatever reason, I liked what Pete said about taking your power of attorney to your bank and other institutions to have them answer the question, is this going to be enforceable if something happens to me? You need to do that, please. And I'm thankful that Pete gave you that admonition. Very important. But bottom line is that may not be enough. Bottom line is if they say no after you become incapacitated, then you have to go through the process of conservatorship, which you've talked about. The goal here is to have you, during your life, while you're capable of signing something, transfer those assets because you can sign your name to your trust. We call that funding the trust. Okay.
Let's go to your next slide.
Okay. So here are the major, what I call pieces of the puzzle for the estate plan. And the one we're going to focus in on today is this one, the trust. All right. Any questions, Pete?
Nope.
Okay. Pete's my client right now. Okay. So here are the differences between a will and a trust. A will dictates where your property is going to go. Guess what a trust does? It dictates where your property is going to go. Your will requires administration, but through probate, whereas a trust requires administration, which is a private administration. So as opposed to everything becoming public under a will, under a trust, everything's private to some degree, and we'll talk about that degree as we go through. A will's expensive. On $1 million type of $1 million estate, it's around $50,000 in fees, not taxes, but fees associated with transferring the property. On a trust, you know, in a major estate, $1 billion estate, it could cost more than that. But the key there is it's private and it's not part of the court's logs of your estate, which everybody can see. The next one is it typically does not require a bond, but if your will isn't drafted properly, it could require a bond. Whereas in a trust, typically the drafter of the trust is not going to require the trustee to have a bond. But mind you of the fact that when you have a trust, you have to trust the person you're naming as the trustee, which we'll see in just a moment. Then finally, estate taxes. A will and trust really can pretty much have the same language in them with regard to how estate taxes work. We're going to talk about that in just a moment. So mind you of the fact that the will and trust really doesn't do that much difference. It's just how you structure the will and trust as to how the tax effect is going to basically be enforced. Questions?
Nope. Next slide. You did pretty well technically there, Jim.
You know, I'm a quick learner. Then there's the will and the trust. Again, wills are public, trusts are private. The wills basically govern the property in your name. So what does that mean? A lot of you folks have assets in joint tenancy and they think, oh, well, we're fine. If husband dies, it all goes to the wife, because if husband dies and the wife survives him, basically wife gets the property outright by operation of law. You've talked about joint tenancy. The problem with that is you're assuming something. What are you assuming, Pete?
You're assuming that the wife is going to do the wishes of the first spouse.
Yeah. And there's also another thing you're assuming is that they don't get killed in the same car accident.
Yeah.
Or they don't die simultaneously, or, you know, with COVID, God knows what's going to happen. So the idea is not to create a fear with you, but to understand that joint tenancy does its job, but it doesn't do it as well as maybe putting it in a trust, where essentially that when the first spouse dies and gives everything to the surviving spouse, it's in the trust. So the trust doesn't assume that either one of the parties are going to live forever. It assumes that at the death of the surviving spouse, the property then is going to be distributed by the terms of the trust. Whereas over here, the court could get involved by intestate succession and cause it to go to people that you may not want to have it. So essentially, we want to probably think about, if not completely do, a transfer of your assets to the trust so that technically, legally, you don't own them, and hence we eliminate probate and conservatorships. Under a will basically, the beneficiaries receive the property at age 18 unless the will states otherwise. Whereas under a trust, we have adopted a plan pretty much across the board, except in smaller estates, as to maybe leaving the assets in a trust for the child, called the lifetime benefit trust. Now, you know, the client is going to have to really understand what I just said and buy into the process of keeping it in trust for the child. And in some situations, such as my son Dylan, it's going to be important that Dylan has a trust for the rest of his life, because Dylan is never going to be able to handle, i.e. manage his own estate. So it depends on the child. If you have a child who's a financial wizard, perhaps you leave that in trust for him for a certain period of time, but then allow it to go to him outright at a different point in time.
Jim, is today, you've got a master's in taxation. And so a lot of the estate planning in the past has revolved around taxes.
Mm-hmm.
What does it revolve around today?
Well, for taxes, it's uncertainty. Okay,
Well,
but
Yeah,
But typically, my practice, I almost had to have a frontal lobotomy to get to the point where I understood all the tax consequences. But now it's more about asset protection, perhaps, avoiding predators and creditors of your beneficiaries.
but it's more
helping
about
them.
the family.
Well, yeah, it's about making sure that there's family harmony.
Yeah.
The point that I think you're making, Pete, is that in a good plan, we can preserve family harmony to a degree, a greater degree, than if we don't plan properly.
Yeah, it's not so much about taxes, and we'll get into that a little bit more a little later on. But
Right.
I love the way you have put the analysis together, with comparing a will to a trust.
Right. Thank you. I appreciate that. It's a pleasure to get your point of view.
It's so rare.
It is. It's refreshing, actually. I feel really good about myself. And then it says requires court approval. A will is in the court system. And Pete, you've been in the court system before, having been a fiduciary for many years now. What's been your experience with the court system?
Right now, it's first of all, it's taken just an enormous amount of time. And it's also, you have in the court system, at least in Orange County, it's a wild card as to what the judge's decision is going to be. And you don't have a jury trial in probate. It's all up to the judge. So in some cases, there are some advantages to going through probate, but generally for us, a living trust is just 10 times better, especially if you're a single individual. And I know you're going to go through that.
So the idea with a court is you don't get to choose who the judge is. You don't get the final authority. You basically are willy-nilly putting it up to somebody's discretion as to what happens. That's what goes through probate in a will. And in a trust, on the other hand, when the assets are in the trust, you have a myriad of different checks and balances. In other words, during your lifetime, as we're going to see, you're the settlors, you're the trustees, and you're the beneficiaries of your own trust. But when you die, the trustee has to step up and manage it for the benefit of your what are called beneficiaries, your heirs, or your loved ones, or your children, or whoever it is you name to receive the benefits of the trust. Somebody's going to manage that for them. Okay. In a court situation, the trustee has an obligation to not only support the beneficiaries, but also adhere to and basically account for the actions of the trustee to the court, who then basically charges a significant amount of money because you have to hire attorneys to basically prepare those accountings. On a trust, however, it's not that way. A trustee still has to do accountings, but not with the court's approval. You basically are in a situation where it's just the trustee and the beneficiaries working together, hopefully in harmony, to make things work. So it's flexible. It's far more flexible than in the court situation where there's this issue of whether or not the court's going to do anything proper. Not to say that the court doesn't, it's just in situations that Pete and I can both tell you, it's a crapshoot as to how the court's going to act.
Never know. You're
You
leaving it
never
up
know.
to somebody else. And but you, under a trust, you get to name your trustee. So, and you could tell your attorney who might have a rogue child or a rogue beneficiary in your estate plan, and they can plan around it. It's just so much more flexible. Let's go to the next slide.
Okay, so is it true that in a trust that your spouse is going to get everything? In the law, under the law, which is basically called intestate succession, and you can see the probate code section there. It's section 6401A, says that all community property that's owned by husband and wife, if there's no will or trust, all goes to the surviving spouse. All right. And so what's the danger in everything going to the surviving spouse, Pete?
The pool boy or the real estate agent.
So I've been more kind now in my description of that person, and I call them a predator. Okay, because they're out there, and Pete and I both know, and we as an attorney firm have seen things you cannot actually describe as being reality. It's just, you can't make this stuff up. Where there are people in the world, if you will, are seeking to take advantage of, especially elderly people who've lost a loved one. In my experience, I've had two really egregious situations where we've come in after the fact, where a surviving spouse has married a predator, and the predator now is seeking to not only love that person, but take all their money. And so a trust can, if you name the right trustee, avoid a lot of that temptation, if you will, for the surviving settlor to try to basically appease the predator who's asking for money. It's allowable if the third party is managing the trust to protect the estate from such activities and such predators.
It's
very important.
staying in control, of your finances. And you can stay in control with the help of trusted individuals. It doesn't mean you have to do everything yourself, but you just have to have good people around you. And you can only do that when you're competent and understand what you're doing.
Right. And
Let's go to
the
the
problem
next
is
slide.
when we age, and this is not no reflection on Peter or me, but when we age, we want to control things more. I think that's pretty a common phenomenon.
Yeah.
But at some point, we may not be able to. And the question is, do we realize that that's a possibility? Is it a possibility that at some point in my life, I'm not going to be able to control my assets? And at that point, I'm the most vulnerable to these people out there who may or may not have the intention to come in and take my money.
Yeah, financial abuse is the #1 rising crime here in Orange County. So it gives you a clue. You have to steal close to $300,000 to $500,000 to get the DA's attention. It's just, and it's something that is so difficult to prove.
Yeah.
Mom gave me this money.
Right.
It's so.
Yeah.
Let's go to the next slide.
Separate property, on the other hand, let's say if you have a couple where husband or wife have inherited money, or they brought money into the relationship. In Orange County, you'll see situations where a very wealthy person might marry a person who has less wealth. The property that person with wealth brings to the marriage, if you will, is called separate property, unless, if you will, they what's called transmuted into community property, which we just talked about. So what happens if a person dies without a will or a trust and they die intestate? What happens is if there's a spouse and only a spouse, it all goes to the spouse. Whereas if they have children or heirs, basically then it would be divided. If there's one child, it's 1/2 to the spouse and 1/2 to the child. If there's more than 2 children, it's 1/3 to the spouse and then 2/3 to the children.
If somebody has let's say in a second marriage, they have separate property and they have community property, should they have one trust and then label inside that trust what is separate property and what is community property? Or should both parties have their own trust?
You're gonna love this, Pete. It's the word depends.
I know. God, you attorneys are all the same.
It depends.
There's no easy answer.
Well, I think there's just a matter of practicality. It's a pragmatic view of the world, if you will. If it's a significant estate that's separate property, you probably want a separate trust.
Okay.
Only because you don't want to call into question about what of these assets were separate property, and in reality, how do you account for them if it's all in one bucket?
So
But if these separate property assets are over here in a separate trust, it's really easy to trace where they came from.
okay. So
But when
more
you
than
commingle
likely,
things-
a separate trust would be the first thing you would look at If it's a smaller estate, smaller separate property, you may be able to do it in the same trust. Good answer, Jim. Take the next slide.
I think you just answered it, Pete. I'm not really sure. The next one basically is that, what did I do? Let me just go away. Unless you're comfortable with leaving the state to determine how you're going to dispose of your property, your best choice is a will. But in essence, if you have just a will, you're going to be going through that probate process. So I'm going to skip over a few of these and get to the point where we need to be. Obviously, the cost of probate is based on a schedule of fees. So if you add it up on $1 million, you'll see the first 100,000 is 4,000. The next 100,000 is 3,000. The next up to 1,800,000 is $16,000 for the attorney, and $16,000 for the executor.
So does that mean that if you administrate a trust, it's free?
It depends. I mean, the attorney's always going to get their pound of flesh, right?
Right. So a trustee is going to hire an attorney to
Executor.
do the trust administration. Highly recommended, by the way. So there is going to be some fees there. It just isn't going to normally will amount to the fees under probate.
Right.
Okay, let's go to the next slide.
But I don't want people to leave this particular session and think that there's no expense in administration of a trust, because that's a lie.
Exactly. That's why I kind of mentioned that. There's a cost, and we'll talk about that in a little bit.
Okay. So what are we talking about? Is it cheaper to make a trust than go through probate? What do you think, Pete?
Definitely.
Okay. A basic trust.
I try not to use the word depends.
You know, there's something that's on the market for us older people that calls depends, and I'm becoming very familiar with that.
I now classify them as pull-ups.
Pull-ups. There we go. Okay. So trust administration, what can you expect? That's kind of the idea that people ask us. And I'm not sure, but if it's a smaller estate, do not cringe when the attorney says somewhere between $5,000 and $10,000. And the reason for that is this: there's just a lot of things that you don't know that have to be checked off in order to complete an administration. In our firm, we have a 3-sheet paper with little boxes on the side that basically define everything that could be encountered in a trust administration. And we don't let our trust administrators finish or close that estate until every box is checked or stricken through as to not being necessary. So it's time consuming. And there's a lot of things that just don't meet the eye with regard to trust administration, like sending out notices and waiting 120 days.
A probate right today, if you were to go into probate, will take you at least 14, maybe to 24 months.
Yeah.
What should you expect a living trust administration process, the range to finish up? I know it depends, but that's why I asked for a range.
It depends, but did I say that?
Yeah.
It's always going to be around 9 months minimum, because there's basically getting the client in, creating a basically spreadsheet with all the assets, going out and getting appraisals of all the properties and values for all the assets, because those are important. You've got to be on a spreadsheet to figure out what you have in order to distribute what you have after paying expenses. So there is a process there, and it takes time. And essentially, if you're naming a trustee, if a trustee has no idea how to do that, you probably want to name a different trustee. You want to name a trustee who has some experience in this, because it's going to be easier and less costly, actually, if they do all the legwork. It's when you have the attorney doing all the legwork where it becomes more expensive, and maybe on the upper range of what I've quoted here.
Yeah, and most attorneys, when they're doing trust administration, charge on an hourly basis.
Yeah, they do.
Yeah.
Because they don't
Let's
know
go-
what they're getting involved with.
Let's go to the next slide.
Okay,
So
so,
this is really important.
so you may have a trust. In fact, I see the hands of people out there when I ask the question, how many of you have trusts? And I see you. Actually, I don't see you, but I can imagine that about half of you, if not more than that, have a trust. But you may not understand what the trust does, and that's why we're here, is try to explain to those who have trusts and then help those who don't understand what trusts are all about. So there's parties to a trust, and the first one basically is the settlor. Now, when you look at your trust, it might say trustor, or it could be grantor. And basically it's the same concept that the person who's creating the trust has to be named. And for you as a single individual, Pete, your name would be there as the settlor or transferor or trustor or grantor. Again, those names aren't important. It's just that we be consistent with naming that person. In a couple, it's typically a joint trust unless it's separate property. So for community property, it has to have both husband and wife as settlors. Those people basically define who's going to be the trustee. And in normal cases, for Pete, for example, a single individual, he'd be the trustee of his own trust during his capacity until he's unable to manage his own affairs. And there's language in the trust that defines when he becomes incapacitated. And typically it takes a doctor's certificate or maybe 2 doctor's certificates to determine that he's not capable of managing his own trust.
Recommend today 1 doctor, just FYI, it's so difficult right now to get 2 doctors to declare someone that has an incapacity.
So you're not only naming yourself as the trustee of your trust, but then you're naming successors. So what happens if, the big if, in planning is the worst case scenario. We're always looking at the worst, not the best. If you become incapacitated, you name somebody to succeed you, and that's called a successor trustee. And there's maybe a whole discussion you can have on who should be the successor trustee, right?
We're going to have an hour and a half on what the duties of a trustee are coming up, I think, in a couple of weeks.
Okay, so when you get there, please pay attention, because most people default to their oldest child. Most people.
That's not the best way.
Not in my experience. In fact, what you're doing is you're creating that person to be an enemy of the other children, which is typically not good for relationships going forward. Now, it doesn't say that that older child is going to do a bad job, but if it ever becomes a question for the other siblings, assuming there's more than one, as to what that person's doing, then it can cause relationship dysfunction.
I'm going to ask that we move that one on to a couple of weeks from now, because we're going to do an hour and a half on that one. So let's not focus on that in a moment. There's a question because we've got trust funding in front of us here as one of the items. If I put my house into the trust, if I put all these other assets into the trust, is my homeowner's insurance going to get screwed up because it's in the trust? 1. 2 is, so now I have liability insurance or something else, but if my assets are in the trust, am I still protected, or do I need separate insurance and all kinds of other things? And I'm living in my house.
Yeah, we recommend that you contact, once the deed comes back to your house, typically we as attorneys draft the deeds to put, quote, fund the house to the trust or other real property to the trust. Those deeds are then recorded. They come back to the settlor, the people who created the trust. We recommend that they send copies of those to their insurance companies so that the insurance companies can add that trust to the insured.
Okay.
Does that answer your question?
Well, am I covered? Do I need a separate umbrella policy or anything else to cover me for my
It's not
personal liabilities? I'm sorry.
It's not a separate it's not a separate policy. It's just an additional insured. And they'll add the trust to that policy.
Very good.
Yeah, I haven't found it to be any additional charge at all, Don. And,
Okay, thank you. That was the question.
Yeah, and just informing the insurance company is the primary thing to do.
Yeah, you should.
And yeah, and liability we'll get into that, but it's in the It's Your Money course, we talk about the importance of having an umbrella policy. So we won't go into that here because that's a whole nother topic. So we've funded the trust, which, by the way, what does that mean?
Transferring title from your name to your name as trustee of the trust.
Right. Okay. Title. Check your titles on how you have title to your assets. Let's go to the next slide.
And so then the person, so there's three parties to every trust. The first one we just mentioned was the settlor. The next one is called the trustee. You as trustee are managing your own property. You're given authority under the terms of the trust to have powers to manage the property. You're also given administration powers as to how to do that under the law. What I tell clients typically is that if you own property, there's no contract anywhere other than the Constitution and the laws of your state to tell you what you can and cannot do with your property. It's yours. So you don't have to point to a particular paragraph in the Constitution that says you have the right to do something. And so long as you don't do something illegal, you can do whatever you want to do. But when you transfer it to a trust, technically you don't own it anymore. You're transferring it to a trust where the trustee becomes what's called a fiduciary. The fiduciary manages the property. They have to have instructions. Basically, it can be an individual, it can be a private professional fiduciary, it could be a trust company who's managing it once you're unable to manage it, but they have to follow the guidelines of the trust, which are basically a contract. The contract defines the administration powers and the financial powers of the trustee. Without that, what I call boilerplate, I've gotten to the point in my practice where my trusts are very long. They're like 50, 60 pages.
Why is that?
The reason for that is every year I figure out there's something more I need to add to the power section to give my trustee the power to act on things that I've never ever considered as being something that I personally could do because I've never done it. And so essentially over the years, we've added and added and added powers. We've also had to amend the administration provisions because the law changes significantly over time. And hence, to keep it up to date, it's important that every 3 to 5 years, you at least have somebody look over the trust to determine whether or not it's current.
So the powers in the trust, it almost acts like a Bible.
It
You
is.
can only do what the trust allows you to do. So
And
give me an
obviously,
example.
if I moved from Hawaii to California and I had a trust and I had everything else set up in Hawaii, I need to have it reviewed here by an attorney. Is it going to have to be completely rewritten, or can we just sort of cross out the lines that we like and you'll sign off on it?
Let's don't do the latter, okay?
Yes, right.
Never do that. Just throw that one away. Don't even hear that statement. If you move from California, let's say, to a common law state, what would be a common law state? A state that doesn't have a community property basis. You may want to speak with an attorney in the common law state like Georgia. I always like the word Georgia. It's easy to say. That Georgia attorney is going to look over the California trust, if you will, and determine how it would be affected if you're now a resident of Georgia. Does that make sense?
Yeah.
Okay.
You have to have it reviewed, but trust will be enforced and honored in every state in the union, which is completely different than a durable power, an advanced healthcare directive, and a will.
Correct. In fact, my California trust is as effective in California as it is in Georgia.
Oh, and Hawaii, right?
I don't know about Hawaii. It's kind of across the ocean there. But
Yeah.
yes, the answer is yes. It should be.
It's good in Hawaii.
Yeah,
Okay.
it is.
I know we're going to go through the trusteeship in detail, but is there any difference if you hire a friend or a family member or a trust company or a professional fiduciary? Do they all have to follow the same rules?
Yeah, Pete, we've talked about this in the past, many years ago, that the standard with regard to the trustees' actions is the same whether you're an individual, certified professional fiduciary, or trust company.
Yeah.
It's the same standard. So the problem with naming individuals perhaps could be they don't understand what they need to do. Whereas the private fiduciary or the quote trust company, they go to school to do this stuff.
Yeah.
And they
Well,
probably handled several.
and one of the things that you had mentioned, and this is, if you have more than one child and you name them, one of them over the other as trustee, and there's any type of sibling rivalry or resentment, it comes out at the time of death. And so your attorney really, and Jim kind of hinted at this, your attorney really has to kind of poke a little bit and talk about to see what kind of relationships is, because if you name one over the other, it could break up the family.
And you know, it's not only the siblings themselves, you have to drill a little bit further down into who they're married to.
Yeah, well, the outlaw.
So what's the joke, Pete? It's
You
what's
want
the
to have an
difference
in-law than
between
an outlaw?
outlaws and in-laws? What's the difference
Yeah,
between outlaws and in-laws?
yeah,
Outlaws are wanted, right? And that's a joke. That's not to be taken seriously.
Yeah.
But in some cases, we've seen that play itself out.
yeah. And you've been in the industry or in the as an estate planner long enough. Most attorneys kind of skip over this part. Give me a name, plug it in, because you can't charge until you have the document done. And one of the most difficult things for people is to name their fiduciary. That's why we're going to go through that an entire hour and a half session. So let's not belabor the point right now. Talk about beneficiaries.
Well, again, if the couple or the single individual have children, typically those are the beneficiaries.
Yeah.
Okay, but the most important thing for your advisor is to determine, okay, tell me about your beneficiary. What's going on? Well, my beneficiary has a master's degree from MIT and basically has a financial advisement. She has an MBA and she knows everything about finance. And I say, okay, great. Maybe they get their distribution outright. Aside from the tax and the asset protection provisions I'll talk about. But if it's a child like my son Dylan, you would never want a special needs child to become basically the owner of the assets that were otherwise in the trust. You would want to protect them from themselves. So you got to really look into every beneficiary. And it's not just as a group, you look at them individually to determine what's going on. And so your attorney or your financial advisor who's helping you through this should be asking those kinds of questions. What about
are you going to go through some examples later on, or do you want to go through some examples here?
Let's do it now.
Okay, let's say, what would you do for your son Dylan? What's it called?
A special needs trust.
And why would you put that? Why would you put a special needs trust together?
Because right now Dylan has Medi-Cal, which is the California equivalent to Medicaid. My wife has IHSS, which is basically a payment to her, tax-free, for the privilege of having Dylan live with us because he's an adult. And basically, otherwise he'd have to live in a group home, which is going to cost the state twice as much. So he's a participant. He's a participant. She's basically the person who's watching over him so he doesn't hurt himself. And it's a really nice plan. If you would give my son Dylan an outright distribution, then all those government benefits go away.
Yeah, not eligible for it. And even if there was the money for it, you wouldn't be eligible for those benefits. So special needs trust becomes super important for someone who has autism, mental deficiency, any kind of a deficit or an issue requiring government benefits.
Right.
What about an alcoholic or a druggie? There's a few of those people around. What would you do for them?
Well, those are what we call lifetime benefit trusts. And lifetime benefit trusts are otherwise known as dynasty trusts all over the nation. The idea is to have a separate trustee, a third party trustee, otherwise a fiduciary who's going to be around for a long time, a trust company or a private fiduciary who's going to manage it for that alcoholic child or that drug dependent child. And the good news is you can develop incentives for the child to receive money. In other words, if they're using, they don't get money to help them, basically enable them to continue to act in the way that they're doing. And the money can be used for rehabilitation, for programs. It can be basically used to pay for their housing and their support, where they don't get the
Psychiatry
money.
help, counseling.
Yeah,
Psychiatry help, counseling,
yeah,
whatever they need.
right.
What about,
And
what about-
the key there is you're basically leaving the money to them, but you're not giving it to them. You're helping them, you're not enabling them. And that's the most important thing.
what about a spendthrift child who just declared bankruptcy a number of times, just can't handle money?
So there's a way to structure a trust where even if the child is bankrupt, that the money that's in this trust for them is not available to them. And hence the creditor can't attack it and pull it out. But the trustee, who's basically managing it, can use the money for their benefit to pay for their housing, their clothing, nutrition, and keep them going. So they're not living under a bridge someplace.
So I see this particular circumstance more often than not, and that is the beneficiary is married to someone that's totally controlling him or her. And I am concerned that if I give him or my beneficiary the money, that the whoever they're married to is going to grab that money and not spend it or wisely. How can I protect my beneficiary from their spouse?
Not give them the money.
So I would put it in, give it to them in trust.
In trust, and have a third party, not them themselves, manage the trust for the benefit of the beneficiary, not making required distributions, but may distribute to them for their needs. The
So-
goal of the trust could be to pay to or for the benefit of the beneficiary. The latter is where they're not necessarily handing the money to the beneficiary to give it to the spouse, but to buy things for them to keep them at a certain standard of life.
Let's say I have one of my child's name is Norm for normal. And so normal or Norm is perfectly capable, is doing well. I'm leaving close to $1 million to Norm. What should I do in that particular case? Should I leave it to him outright? What would be the benefit of me leaving it to him in trust?
Because if Pete, you're a little older, so Norm's probably a little older as well, right? So Norm may have gone through some life experiences to understand that, making this available to everybody on the planet is not a good idea. But if you have children who are younger or grandchildren you're trying to benefit, if you will, you may want to basically have somebody manage it until they're a little older. Typically, these lifetime benefit trusts are just that. It's in trust for their lifetime.
But
Somebody can manage it for them until they're 35 or 40 years old. And then at 40, let's say, they take over their trust and be able to manage it for themselves for the rest of their lives. Up until that time, the trust is very well protected against their own problems.
But let's say Norm is 45, 50 years old, absolutely normal. Can Norm be also his own trustee of his own trust?
He can.
He can. So
Yeah.
he
Yeah,
could-
the only consequence of that is it reduces potentially the asset protection that's available for Norm.
So could he also then, if he's concerned about asset protection, can he resign as trustee and name another trustee?
Yeah, and in many trusts, not only that, what you just said is true, but we put provisions in our trust that say that if there's a creditor trying to get into the trust and the trustee is that basically debtor, that a substitute trustee called an independent special trustee can take over at that point and basically manage the trust going forward until that dispute is resolved, if
So,
ever.
so in most cases where people are distributing $500,000, I'm saying per beneficiary or more, you really look at distributing it in trust first.
Yes.
Okay, all righty. Let's go to the next slide.
Okay, so the phases of the trust, there are really 3 phases during the capacity of the settlor. That's like, you know, you're looking at Pete, he's very capable, right? He's able to manage his own stuff, and he's going to be the settlor, the trustee, and the beneficiary. What happens if Pete becomes incapacitated? That's another phase. At that point, because he has or does lack capacity, a third party would be trustee. And finally, God forbid, something happens to Pete, he gets hit by the bread truck, he's deceased. The trustee then will distribute the assets to what are called the remainder beneficiaries. That would be his kids, or that would be his favorite estate planning attorney, Jim Leese. Okay.
But I just want to focus just a little bit on the incapacity part. When I become incapacitated, it is so, because all the assets are in your cup, that the only thing that needs to change is that trustee.
Right.
All the assets already there.
So mindful, this is a good illustration of this. Here's Pete managing his own assets. Somebody determines he's incapacitated, the cup follows to the next person in line to take over the trust. Mind you, the assets stay in the cup. They stay in the trust. The beneficiary is still using the assets in the trust because the beneficiary hasn't changed yet. Pete is the beneficiary. It's just who's managing it, who has control of it, changes to someone else to help him.
Yeah,
In
we didn't have to go. The trustee change is so easy to do, because just going to the bank, saying, I'm now the trustee, this is the reason why, boom, your name is on there.
And Pete, I'm getting to the age, having practiced in this area for 40 years, where I get calls maybe once a week to do exactly that. Mom or dad has just been diagnosed, okay, and they have dementia, they have, God forbid, Alzheimer's, and something needs to be done. What do we do? Well, it's easy. If mom or dad can sign their name, they basically go ahead and resign, and the kids or whoever they named as successor trustee takes over and manages the trust for who? Mom or dad who's incapacitated.
Well, my own mother, when she felt that she didn't, when we established a trust for her, she was her own trustee.
Right.
When she became somewhat, a little bit of, she didn't want to manage her own bank account any longer, I stepped in as trustee, piece of cake.
Right.
Then a little later on, she moved to Yorba Linda to live with my older sister. And she said, hey, Pete, you know, I want you to resign as trustee. I'm living with your sister now. I want her to be my trustee. No problem, Mom. Boom. My sister became the trustee. Right. And it went just so smooth. No change of assets, just the change of the trustee. And if you didn't have the trust, nothing would have happened that easily. So a lot of times people ask me, how much money should I have before I have a trust? Well, my mother's estate at the time was $200,000.
Yeah.
So it just worked out really well.
The answer is, if you want a home, you've got to have a trust, right?
Yeah.
I mean,
That's almost it.
Even if you have no other assets, if you have a home, you got to have a trust.
If you're single, I think you almost have to have a trust. Let's go to the next slide.
So again, we've kind of covered this already. I'm not going to
Jim, let me stop you for just a minute. There have been a couple of questions in terms of, we've talked about lifetime trust, dynasty trust, whatever. If one of my beneficiaries is a part of a dynasty trust and there's going to be money coming to them over time, does that affect their ability to get a scholarship or other funds? I know we've said special needs in the case of your son, for instance. Is that a distinctly separate way in which he is not removed from state funds because he has a special needs trust?
Right. So I think it's apples and oranges.
Okay.
The special needs trusts are basically governed by California law.
Okay.
So long as you comply with them, it means that they're available. They still continue their government assistance.
Okay.
With regard to the specific question, will this trust somehow impact the grandchild who's trying to seek benefits or loans,
Right.
or a scholarship? The answer is yeah, especially if there's income being generated from the
Okay.
trust. It's available to that person. Sure.
Thank you.
But if no income is being generated.
And incidentally, you have a little over 10 minutes.
Okay. It's really important to clarify those issues with the estate planning attorney on your particular circumstances, because I've had situations where, as an independent trustee, that trust was not considered in the person's getting a scholarship.
Right.
Because it was a completely separate entity. But anyway, in a living trust right here, first of all, you have the articles telling the family members who they are, a little bit of a history. Then you have the trustee section and the successors. Then you usually have the powers of what the trustee can do. One of the biggest things that I see missing a lot of times out of trust, for the trustee to make gifts. I can't, as a successor trustee, I cannot make gifts unless the trust gives me the power to make gifts. Why would that be important in a trust?
Well, I think your question begs the answer. It is important. I mean, it depends on the client. Some clients love to make gifts and have been making gifts all their lives to their beneficiaries, and others don't. It just really depends on whether they want to or not.
But I can't make a gift just because mom was making those gifts for her entire life if the trust doesn't allow me to make gifts.
Well, I'll tell you, Pete, my trusts allow the trustee to make gifts as have been made by the settlor during lifetime.
Yeah, it's that trust becomes the Bible for your successor trustee. It has to have the powers. The other part is make sure you understand the distribution. How that if you can't understand the distribution, then other people can't. So you want to make sure, even as a lay person, that you understand exactly how your money is going to go. Talk a little bit about specific gifts versus the residue. And then we'll get into the AB trust.
Okay, so specific gifts are what we call either pecuniary gifts or gifts of property. Those typically go outright. So if you want to give your best friend or someone you enjoy, have had spent time with, you could give them a pecuniary gift or a monetary gift. The residuary gifts is everything that's left over after making those specific gifts. So oftentimes we'll have clients who want to give something to maybe a charity when they die. Maybe they want to give it to the library. They carve out a certain amount of money or percentage of the estate. That gift is given, and then whatever's left after making that gift goes to what we call residuary beneficiaries. And it can go outright or it can go in trust, depending on how we draft the trust.
How about personal property? Should you list all your personal property in your trust?
You could, but the reality is that it becomes quite a endeavor to list every spoon and fork in the trust. So you don't want to do that. Typically these days, what we've done in my own practice is have people create a memorandum of specific gifts they want to make to specific individuals. Instead of putting it in the trust, where if you want to change it, you have to change the trust. So it's really easy to change the memorandum by just ripping up the old one and putting a new one in place. The idea, though, is that Pete will tell you that most of the controversies, most of the litigation in the estate planning area arises out of gifts of personal property, because people will fight over the stupidest of things. I had people literally spend $200,000 over a yellow couch many years ago. I've had people fight over a sewing machine several years ago. And I had several people fight over a 57 Thunderbird, and I was right there with them. I would have fought over that. But the idea is that what mom could have said to one child 10 years ago, oh yeah, honey, you're going to get the wedding ring, and then forget about that and say to the other child, no, you're going to get the wedding ring. When you pass away, there's going to be an ambiguity there. And guess what happens with stuff? People fight over stuff. So you got to be really, really clear. If there's something specific you want to give to some person, you've got to either put it in the trust, which I don't recommend, or do a memorandum of trust that's incorporated by the trust to make that happen.
And would you make the trustee the final arbitrator?
To the degree that there's disputes, make the trustee the final arbitrator. Absolutely. That way you don't have to go to court to get a judge to decide because they're too busy.
Yeah. Let's go to the next slide.
So this is what we basically call a typical married couple trust. Now notice at the top of the chart there, you've got a joint trust. You have a husband and wife. This is not going to apply to a single individual. So this is just for a married couple. Typically what happens is if everything in that joint trust goes to the left side of the screen, you see that where you have the surviving spouse?
Mm-hmm.
That's going to be held in something called a revocable trust. Some people call it the survivor's trust. Some people call it trust A. That is revocable, which means what, Pete? If the surviving spouse remarries, where does that property go?
Can go to anywhere the survivor wants it to go.
Okay.
To the next husband, to anyone.
So the concern is that if the deceased spouse wants to make sure that the deceased spouse's share of the community property or the separate property is going to go to their heirs, their children, then they would want to protect it. And you do that by creating what's either called a bypass trust or a marital trust. And you'll notice that those are locked up. Those are irrevocable trusts. They don't change. Now, the good news, if you will, is that in that scenario, the surviving spouse still can use the money from the deceased spouse's trust for the surviving spouse's benefit for a lifetime. So they're not out of the woods. They're still receiving benefits from the trust. It's just when the surviving spouse passes away, eventually then it goes to the heirs. Do you see the lineage there?
Yes. Yes.
Okay.
Now,
So
it used to be when you put the AB trust together, it was for tax purposes.
Right.
What are you doing today for family purposes?
Because we're still wanting to be concerned about the deceased spouse's share going to a predator or a creditor of the surviving spouse, we're still creating trust, but we're basically modeling the plan to go into what's called the marital trust. See that trust C? The trust C basically is a trust that's still irrevocable, but unlike the bypass trust, gets something called a step up in basis at the second death.
Because the B trust doesn't get another step up.
Correct. So give me an illustration.
$1 million estate, married couple.
Buy a house for 500,000. It's now worth 10 million.
Yeah.
Right? Lido Isle. That's exactly what it is. So bottom line is, if the deceased spouse dies, when the deceased spouse dies, half the value of the property, assuming it's worth $2 million when the deceased spouse died, would go into the, let's call bypass trust. And then the other half, if it was that amount, would go into the survivor's trust. At the first death, that becomes the basis of the property for income tax purposes when the surviving spouse dies. So if it was 2 million, there's $1 million basis to the survivor's trust, $1 million bypass trust. But when the surviving spouse dies, it gets a step up in basis again to full fair market value. So if it's now worth 10 million, the survivor's trust basis for capital gains purposes is 5 million. The bypass trust remains at $1 million.
So today, you're not doing very many AB trusts. You're more likely to use what's called an A C trust
Correct.
because of that step up in basis on the second death.
Exactly.
Okay.
Exactly. Now,
We got
mind you,
five- just so you know, Jim, we have 5 minutes left.
okay. So we've talked about protecting the beneficiaries, what the lifetime benefits trusts are. You can go over this slide, but it's basically what we've covered so far is the property is held in trust for each child. Okay. And there's spendthrift provisions. Spendthrift provisions basically are the ones that protect this from outside parties coming in and taking. Estate taxes. Well, I'd like to say that there's some certainty here, but there really isn't. The only thing certain is it on this chart at the right side of the page down below where it says 2018. That's where we are right now. $10 million plus cost of living per person. With the cost of living, the current amount that can pass tax-free, in other words, if your estate is large, is $11,700,000 per person. And so essentially right now, $23.4 million can pass tax-free at death. But with the Biden and the Bernie Sanders and the other people's bill that's currently in Congress, they're trying to reduce that back to what it was in 2011, which is 5 million plus cost of living. Now, mind you, under the 2017 Tax Act that increased it from 5 million to 10 million, it's due to expire in 2026 anyway. And so many of the conversations you're seeing in Congress right now probably are based on a give and take. And so if there's anything that's possibly going to be preserved, it's this $10 million plus cost of living. Because in essence, the overall benefit to the government is very small for those estates that are in between 5 million and 10 million. It's for the larger estates where they're going to potentially be able to generate revenue. And then why can't you just throw that out in order to get what you want, which is the infrastructure and the other soft skills?
So your crystal ball is that the likelihood will be 10 million.
That's my crystal ball.
Okay.
Now, I heard 3 pundits from Washington talk about this the other day. Of the 3, 1 said, no, it's going to go back to 5. And 2 said, it's going to stay the same. So you got 1/3 of the human beings who practice in this area saying, no, it's going to go back. And then 2/3 saying, it's going to stay the same.
Nobody knows.
Let's go
Who
on.
knows? Who
Let's
knows?
go on.
Okay.
Nick,
We all talked about special needs. Let's go to the next slide. We're going to have an entire session on IRA planning.
Good.
Got to have the two work together. And I love the last line, don't delay. Let's open it up for questions.
Jim, why don't you stop sharing? There should be that red box that says stop. There you go.
Hey,
And I'll join it too. Okay,
There
we have
you
a couple
go.
of questions along the way. One question is, okay, but I have a Canadian in my family as a beneficiary. Is that going to mess this thing up? Sorry, I had to do that.
terrible joke. Don.
Aren't there some of these things that if your spouse is not a US citizen, there are ramifications?
If your spouse is not a citizen, yes, there's ramifications, especially
But if
in
it's,
larger
but
estates.
if the relative is simply a other beneficiary other than spouse, it doesn't matter who they are.
Well, from our point of view, it doesn't matter, but it could impact them in the state or the country in which they live.
Okay,
What I have a Canadian beneficiary, Don. What we're going to do is that the death of the client is get together with a tax person who understands Canadian
there you
law
go. Okay,
to see whether or not the living trust ought to be situs here in California or another state
okay.
or in Canada, depending on the beneficiary's best
Okay.
interest.
Another question, and I love this one because we get asked it all the time. Can I put a clause in that said, if you don't agree with this thing and you're going to protest, you're out completely?
You can. It's called a no contest clause.
Is it enforceable?
But let me admonish you.
Yes.
Give something to that person.
And the same thing is true also. And I'm gonna guess that you're gonna say, I want to disown one of my kids flat out. The suggestion that I have heard is give them something, acknowledge that they're there, give them something and limit it to that, and perhaps even have a note as to why you did it. If you just say they're out, that rarely is a good thing.
So people always ask me, well, I'll just give them $1. And I said, well, that's really going to tick them off.
Yeah, oh,
That
yeah.
is really going to tick them off.
Right.
Giving them nothing with some explanation might be good, but leaving them $1 is even worse.
Right.
So what we typically say was, what is enough to keep them from wanting to fight the trust?
Okay.
And if that's $25,000, great, give them $25,000. Because if they lose $25,000.
Right.
Yes. And I find
Okay.
that particular scenario seems to work because they know the person who's been omitted from the trust, they know why they've been omitted.
Yeah.
And so they understand.
I wrote an article about this. It was published in Wealth Counsel about the talk. Now, this is the hardest part for clients to do or comprehend or even want to do. And that is to tell the beneficiary upfront why they are being disinherited. Or if nothing else, tell them that you've made some changes to their plan, okay, your plan, and this is why you're not getting as much. Now, again, that's going to be the hardest part of a discussion with that child. But what you're doing is basically not putting it on the other children,
Right.
to try to explain why mom and dad didn't do this, because then that runs into undue influence. That leads to litigation.
Yeah.
I always like the phrase that if I do this, then my children will kill me. No, you're already dead. And therefore they can't kill you. They may not like you anymore, but they may not have liked you now. Okay, it is 11:30. We have one question that I've held off in here because I like this one very much.
Okay.
Can you recommend an information source to guide me to be a reasonable or logical or foolproof distribution of assets to my 22 heirs? That stopped them.
Answer, Pete.
Well,
What?
first of all, 22 heirs, you reflect society. So any one of those 22 heirs anyone who is immediate family or named in the document can protest what you.
No, different. This isn't protesting. This is how should I distribute to 22 of my heirs? And the answer is any way you would like, and there's no rights or wrongs. And again,
Correct.
they may be mad at you, but you're dead. And
Yeah,
so
percentage.
Oh, I
Yes,
see.
thank
I see
you.
what you're saying. Okay.
Yeah, yeah.
Percentage.
I'm sorry.
I didn't get
question.
that.
Yeah, right.
I do
Do it by
percentages.
I probably,
Yeah,
percentages
whether
is the best way, and they don't
whether
have to be equal, but don't give dollars because as your estate goes up and down, then you can really harm someone else. We're over 11:30, so I'm going to be a good person and say we're all done. I thank you all very much. Jim, I appreciate everything you've said. And again, if you want, go back and listen to this video or watch the video next week when it comes back up. And if you have questions, get hold of Jim. Pete, thank you very much. This has been the It's Your Estate session on living trusts. Clearly, we're going to have a lot more over the next couple of weeks to have the discussions. And I appreciate it. And next week, see if we have as many people. I'm going to do charitable giving in this module. So I thank you all very much. And I'm going to stop the recording as soon as I figure out where the mouse is.